Good morning, everybody. Welcome to the Courtroom Files Live. Happy Tuesday. We'll start out this morning in Judge Simpson's court.
It was just a little bit more if he had done a lot of work himself. But it caused a flood above him, which caused the ceiling to collapse. It denied responsibility for it. Well, actually, what she said is talk to the other guy, get an authorized document, he's responsible for it. There's damage to the premises. Two unauthorized documents living with her. Violation of release. Frankly, I don't think she's already admitted that the other occupant didn't pay his supposed debt escrow. So her own admissions are that she's got something else there. It's a violation of release. I don't frankly think there's a threat.
And what's your position, Stoneman?
Yes, sir. Yes, Your Honor. We signed a lease back in October with Mr. Palmer with Chad from CMH that paid the amount and a security deposit, which Mr. Kevin Salisbury is on that. But me and Kevin Salisbury had an argument, Your Honor. I went to my landlord. He ripped it up in front of me, the original one. And
The original one.
the original lease. And then we made up a new lease, which also he did not give permission to Mr. Kevin Salisbury that he was terminated. He never evicted Mr. Salisbury from the tenancy. He just ripped up the lease and had me do a new lease without consulting Mr. Kevin Salisbury about it. So that original lease should still take place, and I am also guilty with Mr.
Well, do I have a copy of that
Palmer.
alleged?
The first lease?
Yeah,
Yes, I sat there and gave it back to Mr. Palmer, which he knew this. And,
well, but do I have a copy of it?
No, I don't think so. Because Mr. Shad said he didn't have enough accredited time from CMH that he does have a copy of the original lease with Kevin Salisbury on it, I'm on it. And there was a verbal agreement with Mr. Palmer, knowing that my 15-year-old daughter worked very hard for 3 years to get sole custody of her, and he knew this. And he said we didn't have to add her because she was a 15-year-old. And
What happened with the damage to the premise?
that, sir, he called me on my phone, and I was at work.
He who?
Mr. Palmer called me, and he said there's water going upstairs. I said, well, I'm at work. Knowing that he's a landlord with a key, if he knew there was probable damage, sir, that the expected water was running, he has permission to go into my apartment with his key to go and check on that damage. I have never heard of this after that. Nothing. I've never seen a bill, never seen anything. I paid my security deposit, so if he had out of pocket expenses, sir, he should have used my security deposit.
She can't do that. So why'd you sign this other lease?
Out of anger. And I went back to Mr. Palmer and I told him there, and he had no problem. Maybe I should have talked to him at a different circumstances, Your Honor. Because Mr. Palmer sometimes was not. I will not say this. I will not retire car, but Your Honor, my thing is if he had damages, I wish he would have shown me proof. But he did have access to my apartment. No, he had a key to it.
I mean, you're not claiming that there aren't damages.
I don't know if there is, or he never gave me no proof.
Who is it you say has this other lease?
I mean, Mr. Palmer. That's who I handed it to.
But you said somebody else has another copy?
Chad from CMH, yes, sir. And he didn't have an adequate enough time, and I've also.
What do you mean he didn't have adequate enough time?
When I went and talked to him about it, he said it's gonna take time to about everything, and he knew that I had court today. I put that in my written statement. I also stated that, I asked for, for him to give me proof. If he can give me proof that there was damages and that he could work on the floor, that it was flooded, he should have some kind of record of the cost of that. So And he did have that possibility to take it out.
So is this other individual residing in the premises?
Yes, he is. And he is willing, I think he's gonna make his own motion with Mr. Palmer.
His own what?
He's gonna be taking Mr. Palmer himself to court. Off late trying to whatever, because he still legally should be able to be there with the lease that his grandmother has, or whatever he's trying to find. And my daughter, she's 15 years old, Mr. Palmer. And I'm not saying this, but you know, normally, I mean, my daddy always said handshake is better than this. And I did trust Mr. Palmer's word, and he trusted mine. And I'm guilty of, you know, some things myself. I'm not saying that.
Was there another lease, Mr. Friedman?
In other words, Your Honor, the lease that's in place is the lease with her alone, one occupant, her. They had no other occupants are authorized.
So I guess my question is a little bit more specific than that. What I hear the defendant indicating is that there was a lease that included two people. That somehow what she's basically claiming is that impermissibly that lease was terminated and this lease signed. Is that correct? Do you know?
Yes, it was.
Do I have a copy of that other lease?
It was destroyed. It was destroyed.
Yeah. Under what basis then was that lease terminated and this new one put in place?
When the man in question took her car and totaled it, I mean, I didn't see him. She said, I don't want him here. He's here, he's trespassing. Is there any way we could rewrite something so he cannot be here? So I said, are you sure? I said, give me the only sole copy of that lease. And I destroyed it, I shredded it, put the lease for her, so she wouldn't have to worry about this person bothering her. And then he shows up right before the holiday and said, oh, he's my guest for the holidays. Starting before Christmas and continuing until today. I mean, still there. And then 3 weeks ago.
All right, well, how long, that would not be a proper way, just on the face of it, to terminate the lease, the previous lease, and then enter into this next agreement
He had left.
and then seek to evict her for what may have been that prior agreement. I mean, there,
Well,
go ahead, Mr. Friedman.
he left, and he.
I don't-
And so, and basically, I mean, and she's saying, I don't want him around, he's destroying my car, he's left, I don't want him around, I want a new lease. So he does, you know.
But the question is how was his interest in the property as a tenant terminated? I mean, we get into a very strange world if leases can be terminated by somebody tearing up the lease.
So he did abandon the premises.
Do you agree with that, ma'am, that he abandoned?
He did leave because he was in the hospital, Your Honor. He did total my vehicle. He was in the hospital for a week. He definitely came back, and that's when Mr. Palmer called me about the water, Your Honor. During that time, he already knew Mr. Salisbury was staying there. He knew this. How come he knew about that?
Okay, so how long did this gentleman leave for?
About 5 days in the hospital, and I do have proof.
Well, okay, so hold on. You and this other gentleman are in some type of relationship, with that be the case? And so as I hear it, Mr. Palmer, something happens as a part of their relationship. She tells you, and then you tear up the other agreement and enter into this new agreement. Is that,
Yes, she said he was gone. She didn't want anything to do with him, doesn't want him there because he's trespassing. So to save her from, I don't know what kind of trouble, she said, he's not coming back. She said, no, I don't want anything to do with him. I'm done. It's done. So I said, well,
okay, so how many times have you heard that in a relationship? I mean,
I don't,
I mean,
I'm sorry, I just don't deal with it. I'm just waiting.
I know, I'm just saying,
I just,
I mean, on behalf, all parties, at some point, will tell anybody else, I don't want somebody there. I mean,
he was physically gone. He'd taken her car. He totaled her car. He was in the hospital for 5 days. The day he came back was the day she left, I guess. And when he turned the shower on, I don't know, it was running for an hour at least. I'm banging on the door, banging on the ceiling. I knew somebody was in there, so I didn't want to go just walking in there. As she said that I had keys to enter the property. I didn't.
which you do.
Yes, but I didn't want to just go walking in there. I'm banging on the door. Somebody was physically in there. I didn't know what was going on. I couldn't turn the water off on my half, so.
So then. I'm not even clear what to do with this because I've got this other lease that sounds to me like it's not properly terminated.
Doesn't exist anymore.
Well, Your Honor, it seems to me though that the only person that would have any standing to raise that issue would be the dude, whatever his name is. And he's not here.
Well, no, the defendant has standing to raise the issue because if part of the reason you're terminating her or the basis for the termination is that she has this unauthorized occupant. And then two unauthorized occupants, who's the other one?
Her daughter.
Oh, for,
He's basically in a pretty good deal for both agreement, Mr. Palmer, when I did it.
how old's your daughter?
She's 15.
So you're claiming that's an unauthorized occupant?
She didn't have the daughter when she signed the lease. She was in custody.
And now you have custody.
Yes, so after 3 years, I got custody, Mr. Palmer knew.
So what am I to do with this daughter?
Well,
I mean, am I supposed to tell her her mother, oh yeah, you fought for custody of your daughter, but she can't stay there with you and your lease is being terminated. So I'm now, because you fought for custody of your daughter, you're now going to be homeless. Is that what is that the position that plaintiff is taking?
That's not the position plaintiff's taking. We're saying is that when you add it all up, there was supposed to be one occupant, now there's three.
Well, no, because Ms. Salisbury, the other lease, there were two occupants. And so so maybe there's three now. And then I'd have to figure out what to do with, I guess, this newfound daughter. And then
there's another 800-pound girl in the room, which is there hasn't been any rent paid since January.
They partial rent in January, 800 at the 1150, and there hasn't been any payment from February to March, which is the tune of $4,400.
go ahead.
With the damages and stuff, also that he's trying to terminate my original termination. Is, he never forthcome, when he called me, I was at work, he talked to me about the water. I said, Mr. Palmer, I'm sorry, I am at work. And he says, okay, I called back again within a couple of hours, and it was off Tennessee, and that is the last time I heard from Mr. Palmer on the issue of any damages. Never seen a piece of paper, never seen any damages.
Do I have anything about the damages since everybody wants to go there? I mean, I'm still stuck on this lease thing, but. Does she have a copy? Go ahead, take a look at it, ma'am.
I did not think this is the first time I've ever seen.
No, I know, but take a look at it. Do you have any objection to the court seeing that?
No, let me see.
Well, hold on. Do you have any objection to me looking at it? Because I don't know what you start talking and I don't know what you're talking about.
Yes, please.
Okay, so. Who's this from?
A contractor?
Okay, does the contractor,
That?
does the contractor have a name?
Yes, yeah.
We have the photos of the damage. Let's see.
No, I understand that, but
Rather ask people more time.
no, not right now. Sometimes it's better not when you're ahead. So. It's $625.
Yes, sir.
Okay, but have you paid this?
Yes, I have.
Is there a receipt for the payment?
I didn't get one from him, but I just paid him cash, gave you that as a receipt. As it says there, paid the final amount.
By somebody who it doesn't. Okay.
If you see the pictures, you'll see the 625 as a parking.
Okay, I don't. Here's the problem that I see. First thing is this other lease. Because I don't know if this other lease is the same as this lease, but just the names change, or if there's something different in it. I don't know that. That's the first thing. Second thing is I am still unclear as to how he, in essence, terminated a tenancy by tearing a document. Because the reality of what he did would not only be to terminate the tenancy of the other individual, it actually terminated her tenancy, and then she enters into a new tenancy, supposedly. But I don't know that that first tenancy was properly terminated. If it's not properly terminated, there's at least an argument that this lease that you're seeking to terminate her is void or voidable, and that other lease is the one that applies. All right, that's my just initial thought on this.
Certain hand.
Go for it.
I
I don't know why you were involved in their relationship. So go ahead and you tell me what you want to tell me.
I was not at all. I thought, by the way things have went for her, and she was coming to me and saying, hey, I don't want him here. Basically scared of him. I don't know what the situation was. If he's here, he's trespassing. Can we do this? Her and I stood there, and that's what we agreed to do the new lease.
I wonder if I could have done that with my mortgage company, Maxwell. Could I? I mean, I'm just asking. I mean, if stuff works that way, Alan? Okay, all right, I'm just checking.
I think this is the thing where he thought he was doing her a favor and.
I know, but, and I get that, Good Samaritan and all that wonderful stuff. But then I'm now here, and because this guy came back that she may have been mad at him for a while. They patch their differences. I don't know, her car gets repaired, whatever. And then because she does that, and because there's this damage, I get the damage part, but because she does that, the one basis upon which now she's being terminated, it seems, is because she repaired her relationship, and also is being terminated, I guess, because she was successful in fighting for custody of her daughter. This is a beautiful scenario.
Well, we didn't raise the daughter issue, but it's.
Well, no, he did. I mean, so let me ask this, Mr. Friedman. Is part of the basis for this other person her daughter? Part of the basis is that she has unauthorized occupants. Is your client claiming that the daughter, the minor child?
We didn't mention the daughter.
Okay, so is that an issue?
We're not raising it. It's a fact.
Well, he did. Okay, but when I said there's an unauthorized occupant, somebody said two. And so one of those would be her daughter. So what I'm asking is part of the claim in this case the daughter in the premises?
No. It's a fact, but it's not, we wouldn't have terminated the tenancy because of that. No. We're terminating.
Okay, so I don't have to worry about the daughter.
No.
Okay.
But we do.
I just have to worry about this guy that she got mad at, that all of a sudden the lease gets torn up, that then they repair their relationship, and now he's an unauthorized occupant. That's the only one I have to worry about.
And the fact that he caused the damage, yeah.
Okay, I mean, we can get to the damage part, but and what?
They haven't paid rent since January.
Okay, but I've got a termination case
I
in front of me.
understand, but you're gonna have, it's a 7-day case in 8 days.
Okay, so, ma'am, the individual that has a copy of this initial lease, how long did they say that would take them to get?
And we'll figure it out. And what happens. I did propose to Mr. Palmer through Ms. Jill that I would like to be out by May 31st. I'm willing to give the security deposit by 50, and I'm also willing to pay the first month's rent in May by the 1st of $1,100. I would like to be out by May 31st.
So you want to pay $1,100. He keeps the security deposit, you don't have any claim over it, and you just want to be there till May 31st. Well, hold on. Yeah, there could be an immediate trial. However, I've started a trial, I guess, but I've got an issue because of this other lease. So, and it's not here because your client says it's destroyed. She says there's a copy that exists, but she can't access it at this point. She's going to try to access it today. So it would seem to me that I would adjourn this in any event.
I understand. This is my first trial. My first time in front of your honor.
I know. Yeah, I know. You can see where it's going.
But I would say this, if I was inclined to make that suggestion, I would want a COD because
and I think that could be in a COD. She seems very definite that she's going to do these things and then leave. I don't think your client likes the idea. So why don't I just adjourn the trial? And my next date isn't until like late April anyway. Huh?
April 22nd.
So it would be April 22nd. We'd have a trial. I don't know. I don't know how long it would last. We might get till the end of May in any event. But I mean, if that's her proposal, it seems like a reasonable one. She doesn't want to stay. And by the way, the other thing that's faced is that if I find that the lease here is void and or voidable, you're going to lose anyway. Once I see that second lease. Or at least there's the potential. So here's what I'll do. You're going to get a copy of that other lease. I'll adjourn the non-jury trial to April 22nd, 2025 at
9 a.m.
9 a.m. And something we've learned today. If your lovely wife starts yelling at you, just give her a notice to quit. All right.
I do want to use the request for escrow. Give it back.
I understand, and that would be my next available date for a trial. So you're entitled to an immediate trial, and she's gonna pay her escrow. Bye. I guess she's leaving. Okay. All right. Thank you.
Alrighty, I gotta say, if I gave Mrs. the Courtroom Files a notice to quit because she was yelling at me, she'd just rip it up and throw it in my face. Good morning, everybody. Welcome again to the Courtroom Files Live. The birthday kitten Ellie is currently playing at my feet. She'll and whining a little bit. She's no, she's up here now. You're in a mood today. Come here, say hi to everybody. You wanna say hi? Meow. All right. I know you're in a mood. It's your birthday. You should be happy. So anyways, like I said, good morning. It's nice to have you all here. These landlord-tenant situations like we had here with Judge Simpson right now, these things are always messy because either it's an exercise in misery where people are having trouble paying, or it is an exercise in broken relationships. It seems like it's one or the other. So they're never comfortable for anybody involved, that's for sure. Let's go over to Judge Boyd's court and say good morning to her.
when it comes.
Oh, thank you, Your Honor.
All right, so we're going to go on the record in 2024 CR 011808, State versus Teresa Frias. Could I have parties announced for the record for the state?
For the defense, Renee Munoz, Your Honor.
And are you Ms. Frias? All right, so the court received the report back from felony drug court. Counsel, I think that felony drug court would be appropriate for her.
I agree with Your Honor with that assessment, to see if she can be evaluated and meets criteria for that. I know that my clients have experienced trauma in the not so distant past.
Mhm.
In terms of being a victim on an aggravated assault with some pretty substantial gunshot wounds, and she's been out in the community, and I explained the situation with the positives, and that it's addiction is sometimes steps you have to work through, but that the court will likely be recommending that felony drug court. And I was telling her about the program, explaining to her, you know, it'd be some years of probation, monitoring, and treatment as they deem necessary. We're perfectly fine if the court wants to make that referral, Judge. Due to some of the overcrowding issues at the jail, we wanted to see if she could report on outside in the community to see about the evaluations she's been making in support here as ordered. She hasn't picked up anything new.
Oh, and can I have the, that printout again?
Oh, yes,
please?
sure. Sorry. Thank you. To address her substance use issues.
All right. So do you live by yourself or there are other people in the home?
I live with.
Hmm?
I live with.
All right. And, oh, I'm sorry. Can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you can lower your hand, state your name for the record.
Chris.
All right, are there any minors in the home?
I have a 16-year-old.
All right. And how many children do you have total?
I have 6 total, but I just have the 6.
All right.
She's with me
And
half.
I'm sorry?
She's with me half time. Like
She's what?
she's with me and then with dad. So I get like 2-3 days. She'll be with him. The rest back and forth.
All right. And who is your support system?
My boyfriend
Mhm.
and my, I guess, in-law.
And so do you live with your boyfriend and in-laws? All right. And how long have you been living with them?
I say 8 months because I just got out. I don't know if it counts, but the jail time.
Okay.
I was in there for 6 months.
And I will tell you, and your counsel will tell you, I require that probation does field visits. So if you're going to be staying there, probation is going to come in and do field visits. And if they don't want probation doing field visits at their house, then you're not going to be allowed to stay there. You understand?
Yeah.
All right. And you all recommended deferred, but neither of you all put down outside the agreement what length you are requesting. So it's
2 years.
Mhm.
That's our understanding, Your Honor.
all right. So what I can tell you is I'm going to give you more than the 2 years. The reason being is because drug court is a 2-year program, and sometimes, well, not sometimes, they have a 2-year program, and the aftercare program is 6 months. Now, whether you're in that program for the full time really is dependent upon you and how you do in the program. You understand?
Yes.
All right. So the court is going to sentence you to 3 years deferred adjudication, regular reporting by Zoom or in person, regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month until further notice. There should be a referral to felony drug court. How far did you go in school?
I graduated.
All right, so what are you planning on doing with the rest of your life? What is, before all of this happened,
I was gonna manage it. I love managing.
all right, managing what?
Well, I've always worked at Wendy's. I was at Wendy's for 9 years.
All right, so that's what you want to do? All right. And you know what I always tell people, whatever your dream is, that's your dream. We need people, we need managers. If somebody comes to me and say they want to be a farmer, I'm like, yes, we need farmers. So every place where you see people working, we need those people. So I always tell everybody, no matter what your job is, sometimes we think our job is not important and oh my gosh, what have I been doing with my life? But that job is needed. For example, people will say, oh, that person just bags the groceries at HEB, or that person's just a cashier. And I always tell them, don't say just, because we need a cashier. We need somebody to bag groceries. We need all of that. I'm still upset that they took away the full service at the gas station, but that's just me. All right, so I'm gonna give you 200 hours of community service restitution. 100 of those hours will be deemed satisfied once you complete parenting classes. And another 100 hours will be satisfied if you complete some type of trade school or higher level education. And what I can tell you, some places that you work for, even at McDonald's, they will actually pay for part of your college education or pay for your school. And if you want to really move up quickly in the system, try to go to a trade school and get something in business management or something that will make you indispensable to the company. Because you see at all of these stores where they have now self-checkout, I always tell people, that's a sign. You need to pay attention to that. So can you imagine now you have about 8 self-checkouts in one general area, and they just have one person who works for the company stand there to make sure everybody's scanning things appropriately. Pretty soon, they're not even going to have that person. So that means all those cashiers' jobs are going to be eliminated. So pay attention to, as Briscoe County Junior would say, the coming things, so you can be ready for it. All right.
Definitely good advice. Thank
yes.
you, Your Honor.
All right. I'm going to ask for 90 sober meetings in 90 days. Taking consideration 2024 CR 011807. Yes, thank you. There's to be restitution, if any, and no contact with Gina Rodriguez. And there's to be no contact with Martin Alonso. And Carla, Karla Alonso. And there's also to be no contact with (214) East Mayfield. And that's 78214. Probation, is there anything else that's needed? Okay. Is there anything else you need from the court in order to be successful?
If you need anything else, that's fine.
Oh, no, I think we appreciate.
All right. And did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes.
All right, we can go off the record. Here's the thing. I know that life gets hard for people. I know that sometimes we get into relationships and we're like, we wake up and we say to ourselves, how did we get here? But if we are in relationships that are not good for us, best bet is to get out of that. With regards to drug use, let me explain to you. And I tell this to a lot of people. Sometimes they don't believe me, but you see the news. You'll be able to see if I'm telling the truth or not. There are only two things going to happen from using illegal drugs, and sometimes using prescribed drugs. Either you're going to end up in somebody's jail on a regular basis, rotation, or either you're going to end up in prison. Because at the end of the day, possession cases, possession less than a gram, possession 1 to 4. You know the difference between you and the other person who doesn't get a possession charge? The person who doesn't get a possession charge has used the drug before they are caught, right? So either you're going to end up in jail because you're going to get caught, or either somebody's going to have to identify your body in some field somewhere. And I don't think you want them having to go to your 16-year-old to identify your body. And it will start with, she's missing. We haven't seen her in a while. And then you know what people will say and what the police will say? They would say, but look at her history. Maybe she's just on a bender, right? And then 2 weeks going to pass by. Then popping up on Facebook is going to be your photo, and everybody's going to say, will you please share this? Then the police or some jogger or whoever it is going to find a body in a field somewhere where they're out fishing, or either find a body, on the sidewalk. And then they're going to say, oh, we think it's her. And then they're going to have a relative or somebody who knows you come and identify your body. And I don't think you want your 16-year-old to have to do that, or your family members to have to do that. So whenever you're using, I always tell people, do it. Stop doing drugs for yourself. But if you can't stop doing it for yourself, you know what you need to constantly tell yourself? I don't want my relatives to have to identify my body. I don't want to spend the rest of my life in prison. In this court, to be successful on probation, communication is key. If there's an issue, talk to your probation officer. If you feel as though probation is not addressing it, you can always come back to court and address it with me. Felony drug court, your attorney will tell you that's a great program, but it's only as great as you make it. You have to take advantage of the services they're offering. You understand? And be honest with them. All right? All right. Good luck to you.
Thank you so much.
You're welcome. And thank you for dressing appropriately for court. All right, so here's the thing about that. I understand that sometimes people are dishonest with the court because there are consequences. In this court, I'm fair, but I have to let people know there are consequences. And anytime I'm asking you questions about things, you've already reached an agreement. And normally it's rare for me not to follow plea agreements. Whenever I tell people that I need to know about you so that I can set conditions that will help you, that's exactly what I'm trying to do. Because the last thing I would want to do to somebody, if they have drug issues, I just send them off into the world and don't even address it, because that's not going to be good for you, because that's why you're here, because you have drug issues. All right. So be honest with me.
Thank you.
All right. You're welcome.
Okay, anybody ever notice how Judge Boyd, so often in her language, it deals in like absolutes? Here's the thing I always tell people, here's what I always say. It's just kind of an interesting quirk of hers. If you watch enough of these judges, you pick up on these quirks. Speaking of quirky, let's go to Judge McNally and say good morning to him.
Lamar Thornton. Lamar, people against Lamar Eugene Thornton, 24B 702-123. Good morning.
Thank you, Judge. Good morning, Your Honor. Good morning to your fine staff. May it please this most honorable court. Edward Martell, P 85051, on behalf of Lamar Eugene Thornton, who stands to my left. Sir, please state your full name for the record. Lamar Thornton.
Why don't you two come up to the podium?
Thank you, Judge.
So your client was charged with RNC 20,000 or more, a 10-year felony, and drive while suspend. The plea agreement, you did a great job getting it reduced to 200 or more, but less than 1,000.
Thank you, Judge.
Have you had a chance to review the report with your client? Are there any material additions, corrections, or deletions?
Judge, there is one very material addition, which I would like to highlight to this court. I have reviewed with Mr. Thornton, and certainly he's in concurrence with same. And just for the for Your Honor's full and complete context, the basis behind the resolution, which I believe was a very fair and reasonable resolution. However, our intent was to move ultimately for dismissal because the same transaction and occurrence back in 2023 led to charges in front of Judge Victoria Shackelford in 23rd District Court, ultimately where she was charged with a felony for larceny, 1 to or less than 20,000, and pled to.
This is an offense date of December 28 of 21.
Oh, forgive me.
Right? Am I missing something?
Judge, ultimately, upon information and belief, the same transaction and occurrence led to charges in the city of Taylor. However, the elements of the charges were different. He was charging Taylor with larceny less than 20,000, and in Woodhaven, he was charged with receiving and concealing. And just for full and complete context, because ultimately he's already taken responsibility for both. The allegations originate from the taking of some property from Southland Mall. He was stopped in the city of Brownstown while he was changing a tire. They found the
$37,000 worth of value of stolen items in the trunk.
Correct, Judge. At that time, they traced it back, or ultimately traced it back to Taylor. He was charged in Taylor. He ultimately pled in Taylor and was
To what?
To a misdemeanor. We pled it down to RNC, less than 1,000. However, Judge, what I'm humbly submitting to Your Honor is, well, number one, this is a dated matter. Number two, he's taken full and complete responsibility for this, not once, but twice now. I'm certainly, Judge,
I need to understand something.
Yes, Judge.
There's no way he got convicted of two cases in two different jurisdictions based on the same theft. I mean, if you're telling me that they pled that to in Taylor, why in the world would they have started the charge here? And why would there have been a plea on this charge?
Well, because the elements were different, Judge.
Okay.
The elements were different. They charged.
All I know is right now I've got somebody who got a break pleading it to 200 to 1,000. That had over $37,000 worth of stolen items.
I would agree, Judge.
Okay. That's all I want to know.
And I just want to make sure, give me 1 second, Judge, please. The original event date was 12/28/21. That's the same event date for the city of Taylor, which, Judge, if I can approach, I could show you. But ultimately, again, the only reason we pled here is because they were different elements, and under the, ultimately they charged differently. So while, certainly it appears to be a great plea, ultimately, I believe that this would have went all the way to circuit court. It may have been dismissed. Notwithstanding saying, certainly my client has taken and continues to take full and complete responsibility for his actions. But what I will submit to Your Honor is, number one, this is 4 years old. Number two, the purpose of sentencing, Judge, and the purpose is one, should be punitive, but two, rehabilitative. Judge Victoria Shackelford put him through a rigorous rehabilitative course to which he ultimately succeeded, Judge. So while 24 months probation looks like a gift for this high-level felony, well, it's not.
Was he in the drug court?
He was not, Judge.
Well, what do you mean? So he went through probation?
He went through probation, but her probation is very strict, correct?
I mean.
And he did a number of rehabilitative programs throughout that. Is that correct, sir? Okay. Notwithstanding, same, Judge, what I'm humbly submitting to Your Honor is, again, while it certainly looks like a gift and it was a fair and reasonable resolution, there was a
They've got I don't see any judicial segment out of Taylor. I see a December 30 of 19, and then I see a June 17 of 17. I don't see anyone involving, but now I'll stand corrected if you think I'm wrong, but I don't see anything that shows that he was convicted out of Taylor emanating from this December 28, 21 incident.
Judge, may I briefly approach?
You can have your phone up, sure.
And I don't think that the fine probation department aptly considered that. And
are you kidding me? He's looking to go to jail here today. Are you kidding? He's stealing. He's a thief.
Understood, Judge.
I mean, I'm serious. I'm not going to play games like this. This is crazy. He's got a felony larceny from a motor vehicle from up here, Tabitha. I don't see where you're talking about. If you want to pull it out, he's got a felony larceny from a motor vehicle out of August of 18, felony assault resisting obstructing officer February 19, felony weapons charge October 19, RNC less than 200 from February the 3rd of 20 out of Taylor, and February 30 February 3rd of 22, RNC 20,000 or more in the Third Circuit, and then larceny 200 or more out of Taylor, less than 1,000 from July 3 of 23. I don't see where that has anything to do with this case.
It's just, what I'm humbly submitting to Your Honor is,
You got to tell me what the difference was.
while we're not disputing any prior convictions, what I'm submitting to Your Honor is that this event, which this event here is from the 23rd District Court, which I'm showing this.
What's the arrest segment date?
The arrest segment date was 12/28/21. The original charge was larceny. It was charged in the city of Taylor on forgive me, Judge. The charge date was, they filed 4/13/23. And ultimately, he did plea and took full and complete responsibility. So what I'm submitting to Your Honor is why it was recharged, which the prosecutor can certainly attest to saying, because it was the basis of this resolution. The very reason that we make.
Well, then let's call in Mr. Mohan.
Thank you, Judge.
And by the way there, Mr. Thornton, you've got 1, 2, 3, 4, 5 open warrants. It's time to grow up. Why haven't you taken care of those warrants?
I have taken care of one of them. They just been adding a lot of fines onto them.
All right, thanks. I need to know why, what that plea was on though. If you're telling me that these items were subject of a plea in Taylor.
Correct.
You should have filed a motion and had this case dismissed if it was the same. And if we're talking about the same items.
Judge, we are talking about the very exact same items. However, again, the basis of the charges are different elements. And while we did ultimately reach out to the prosecutor's office for a dismissal, the resolution was kind of a split the baby. So ultimately, again, Judge, while, and I can tell you, and I can attest to you that this young man did have some issues in his past. I mean, ultimately, Judge, he came through the foster care system, if I'm correct, and he's growing into a strong young man. He's a father, he's a painter. I've seen the work that he does, and he's working his hardest to overcome all of these previous issues, Judge.
Mr. Mohammed, do you remember this, your name?
Good morning, Your Honor. Mohammed.
Do you remember this Lamar Thornton case by chance?
I remember that talking to my supervisor about the plea in this case. That's what I remember. I don't remember the exact facts.
Okay, so it was reduced to a misdemeanor, 200 up to 1,000. So that's a 1 year. He was up to 20,000, a felony. Mr. Martell is telling me this somehow tied into a case in Taylor. Do you know anything about that?
Yes, there was another case that arose. I don't know if, again, I'm just going off of what I can recall, but I don't recall if the theft occurred here and he was found there. So he was charged with 2 different crimes. They weren't the same crime, but they do stem out of the same set of facts. But he was charged with 2 different crimes. One was here and one was in Taylor.
I don't know what that means. I really don't.
If I get like 5 minutes, I can go pull up the case.
Go do that. Go do that. I'd like to know. I'll go on to another case.
Thank you, Judge.
Have a seat 1 second.
All right, well, that attorney gets what he needs, and Judge McNally moves on. We'll move on. Judge Fleischer has come online, so we'll say good morning to him.
Marijuana on the passenger floorboard area in Plainview. A probable cause search was carried out, and the officers identified the 2 sacks on the passenger floorboard as marijuana. The total weight of marijuana was 76.37 grams.
Okay. Mr. DeLay, I'm going to find that there's sufficient probable cause to go forward with your case. I'm ordering you not to go back to this gas station. Do you understand? I'm also ordering you now not to consume alcohol, illegal drugs, unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, I will put you in jail. Do you understand?
Good.
No more slinging. Do you understand? What do you do with yourself these days? Do you have a full-time job?
I'm doing application right now. I have an interview tomorrow.
Good. I'm bringing you back in 2 weeks and I want to see that you have a full-time job. Do you understand? If you come back and you've done nothing, it's not going to go well. And I'm telling you, I'm going to drug test you within the next 50 days. If I find that you continue to use, it's not going to go well for you. You understand? All right. Did you want to apply for a court-appointed lawyer? Okay, Deputy Miranda is going to give you an application. I'll have you sign a receipt, Victoria. You will then meet with Fleischer for your bond conditions. I'm also ordering you not to be in possession of weapons as well. Do you understand? Okay, come on.
Yeah,
Go ahead and claim. All right, Judge, next is page 15, Phillips, come on up.
Mr. Delane, did you graduate from high school? What, you said 15?
He obtains GED.
What's
He
your,
obtains GED.
yeah, but hey, 15?
Oh, I'm sorry, Phillips is on page 15.
Yeah, okay. You're, Mr. Phillips, you're charged with failure to stop and give information, leaving the scene of an accident without exchanging information. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
Judge, on September 1st, 2023, a law enforcement officer responded to failure to stop and give information call in Harris County, Texas. The law enforcement officer made contact with the complaining witness, who stated that she was pulling into a parking lot of a corner food store and observed the defendant's vehicle reverse into her direction quickly. The vehicle then rammed into the rear driver's side of the complaining witness's motor vehicle. The defendant's vehicle then quickly shifted into drive and fled the parking lot. The complaining witness took a photo of the rear of the defendant's motor vehicle after the accident and provided the license plate to the law enforcement officer. Law enforcement officer found the motor vehicle registered to an address less than a mile away and traveled to that address and made contact with the defendant. The defendant stated he was at the food store with reversing out of the parking lot and struck the complaining witness. The defendant stated he fled without providing information because he did not have a driver's license. The defendant was identified with his Texas ID.
So can you run his license, please, just to make sure?
Yes, Your Honor, I'm just not showing the driver's license numbers, so I'm not sure if he is part of the license since then, but we don't have it in our system.
If you do not have a license, do not drive. I don't care what's going on in your life. I don't care that you have to go to work. I don't care that a baby needs to go to the hospital. I don't care there's a burning building and you need to save 50 kittens. If you don't have a license and liability insurance, do not drive. You will be signing an affidavit with me today. This is the promise that you're going to make, that you're not going to drive. You cannot justify getting into a car for any reason. And if you do, you can be facing an additional 6 months in jail on a contempt charge. Every time you drive, it's an offense in and of itself. Do you understand? What do you do with yourself these days, Mr. Phillips?
I work and take care of my little sisters. My dad had recently passed away.
You have a full-time job?
Yes, sir.
Did you graduate from high school?
Yes, sir.
Okay. Did you want to apply for an appointed lawyer?
Yes, sir.
Okay. I need you to qualify. I need you to fill out an application. I'll take a look to see if you qualify. I need to know everything about you. Do not drive, Mr. Phillips. If you want to drive, go get a license, get insurance, show me that you have these, and then we can talk. But until that point, don't do it. There's going to be HE double hockey sticks to pay if you do. You understand? All right, come on.
Real quick, the birthday kitten Ellie is sleeping at my feet. She started her partying at 3 a.m. this morning, so I think she's tuckered out, but she might make an appearance later. And I'm just happy she was sleeping while Judge Fleischer once again rages at 50 kittens in a burning building. I don't know what his problem with kittens in burning buildings are, but anyways, back to Judge.
Contact with complaining witness and then no weapons. Vic, what's the last name on the gentleman?
Wilkins, page 21.
You're Christopher Wilkins.
Yes, sir.
Wilkins, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 20th, 2024, officers were dispatched to the address of defendant's stepfather. The complainant was stated he confronted his son about missing items. The complainant was told the defendant to get ready for rehab. The complainant was noticed his jazz bass guitar was missing and observed his neighbor's cameras, which showed his son to leave the house. The total value of that guitar was $480. That was all I have on this one, Your Honor.
Do we know he did it?
Your Honor, it stated that there was.
So dad is saying there are several items missing from the house.
Yes, Your Honor, including a guitar.
A bass guitar.
Bass guitar.
Anything else?
Yes.
Does dad call the cops on his own son?
Oh, Your Honor, it was.
Stop.
Oh, my fault.
Stop. Don't say a word. Are you losing? So why talk?
I'm not sure how the police were contacted here, Your Honor. It just says that they met and spoke with the complaining witness.
Another report written like it's just going through a drive-through.
So, Your Honor, the only thing I would say is, she's facing the VIMs. The defendant had initially declined any of the allegations, but later told his mother that one of the items that was stolen, which was a bicycle, was later stolen from the defendant when he left it at his store.
But here he's charged with a bass guitar. What the?
Okay, Your Honor.
Have a pet lizard named George. Really? Mr. Wilkins, I'm going to find that there's no probable cause to go forward in your case. This life is a very short life. And when you start racking up convictions, it really hoses you. It's really hard enough as it is as a Black man in today's society. And when you start racking up convictions, especially theft convictions where you branded a thief, do you think it helps? No, it doesn't. Get into school, get some knowledge, get a degree, find something to do, and make a lot of money. That's what life's about. Not ending up in court with a theft charge. You know what I mean? If you have a drug problem, address it before it becomes a real issue and it takes a hold and grabs you by the boo-boo. You know what I mean? Plenty of people in there. We don't need any more. Please.
That was the last arraignment, you know. Counsel for reset? Phillips? Clarissa? Clarissa?
Good morning, Mr. Huang.
Good morning, Judge.
What's going on with you?
I have requested a plea, but we don't have one yet, offer. So.
We're talking about Quinn.
On my case.
Do you have an offer on the case?
One moment, Your Honor.
Sure.
Judge, what's the last one?
Bottom of page 8.
Teresa?
Luke? Please step one over, Your Honor.
Yep, take your time.
Go ahead and sign the board.
I apologize, Judge. I was in court 4 and just sitting there for a while until.
Don't worry about it. You're good. We're glad that you made it. Did, hey, Vic,
Yes,
did Stradley come here today?
yes, he reset it.
He already left?
Huh?
He already left?
Yeah, he already left.
Okay. Because we need to do conditions. It's a second.
I can't hear
It's a DWI second. We need to do conditions. I know, but I still want to put conditions. He's gonna bond out, I would imagine, right? No, but I'm putting conditions first. I want to get conditions so we get a guardian interlock and now. Yeah, see, yeah, I mean, I want to put conditions on, you know? And if you can't say that we can give him someone in the interest for now, just for purposes of conditions, okay? It's okay, Tom.
Tom, hear me?
Shh. He can hear you.
Tom, I'm gonna send you an email on this one. I think we've got it worked out. Let me send you an email on it.
All right.
Just let me know when you're ready, okay? Hi.
Thank you, Judge. I just wait here in the link.
Come on up. Yes, ma'am. Good morning.
Good morning, Judge. I'm here on an off-docket matter. Is that okay?
Yes, okay, of course. What's your cost number?
There's 2 and Judge, hang on.
I forgot my eyeballs too.
There's a DWI and that's cause number 2556097. And there's a tampering.
This on Mr. Hernandez?
Yes, sir.
Are you representing him on both?
I am, and Judge, we just realized, I'm sorry, my staff, I just filed the notice of appearance on the
Okay.
tampering. We didn't realize they had 2.
We have you connected.
Okay.
It looks like he has an ice hole.
Well, yes and no, that's why we're in front of you. So he apparently posted maybe the PR bond here. ICE got him from the jail. He went to immigration. April 2nd, posted a bond there. But we've got 2 warrants. I believe these warrants are holding him. And so didn't know if, I think Harris County maybe has 10 days. I don't know for sure. They have a certain number of
What
days.
happens is that you don't get notice, or I guess we didn't realize that he's in immigration. We assume that he's out, he's gone on the lam.
Right.
So
And they didn't
we
have
issued
a
a
warrant
warrant.
to tell you, Judge,
So he's made bond on the immigration case?
Yes.
Okay,
yes.
so I can reinstate these bonds now,
Okay,
but as soon as he gets out, he needs to come here immediately for bond
of
conditions.
course, okay.
So we need to set a day.
What's the case number?
You ready?
Yeah.
It's 2556097. There's 2. I'll reinstate it now, but if he's not here by the next setting, let him know that I'm gonna end up revoking him because he needs to come here for bond conditions. I guess just pick if you want like maybe a week or so. Yeah.
Thank you.
Yes, ma'am.
Appreciate it.
Of course. Did you get the cause number?
Yes.
There's 2.
Anthony Hernandez?
Yeah, please, reinstate both.
Yes, sir.
Just to update, you currently have eyes on 7 different courtrooms. Many of them have actually gone to recess. There is, it looks like some kind of sentencing going on in Judge McNally's courtroom where there's a victim impact statement that appears to be being given at the moment. I'm going to double back on that one later today and probably post a video if there's something there because I believe there is something there. So be on the lookout for that. For now, let's continue to ride with Judge Fleischer.
Yeah, I'll do the bond thing. Yes. There's three friends. He's on this one, I'll make sure on this document, his terms represent the knowledge and makes the things right. So, right, yes, that goes.
It was discovery complete. Okay, what else? What do you? All right, how big is the 26. Let it go to the lead, the fence can be valid in the discovery and consider. Council for reset. Chris, did you get any financial affidavits?
Yeah, for sure. Just for. You know.
All right, I know there's a little bit of a lack of action at the moment in Judge Fleischer's court, but I'm going to continue to ride here because, again, most of the others are in recess, and I'm monitoring this sentencing that's going on in Judge McNally's court, and I do suspect I will post a video on that. It appears to be a drunk driving that involves a death. So as long as Judge McNally doesn't yank that stream at the very end so I can still capture it, I'll do a video on that later. But for the moment, I don't want to go there right now, though, because I don't want to catch it at the very end, and then we don't have any context. So let's, again, let's continue with Judge Fleischer for the moment.
So, council can run with the judge wants to focus on things she done as a tested. Whenever you put
Yeah. Tom.
I'll file dismissal in that case. I filed a dismissal.
Are you talking to me?
Yes, I filed a dismissal on when.
I appreciate it. Thank you, sir.
I'll sign it as soon as I get it too, okay?
Thank you, Judge.
All right.
Thank you,
take care.
counsel. Take care. May I be excused, Judge?
Yes, sir. Thanks.
They dismissed that. So they're not too concerned. And they amended his conditions. They're hoping to dismiss
Yeah.
yeah.
I mean, if that's the case.
Yeah, they can go to intermediate sanction for facility for the 45 days. So he's staying in custody.
Okay.
It's only orders. No, I know. I'm not trying to, I just thought I would actually see more.
This will be nice.
Yeah.
Okay.
And I gotta call the PIO, on a different case. But I gotta call them right now.
There's a little more going on in Judge Boyd's court now, so let's head over there.
All right, court is calling 2025 CR 0037995 State versus Kevin Kenneth DeLuz. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense?
Zachary Munoz for the defense.
And are you Mr. DeLuz? All right, off the record for a moment. John Young.
John.
Hi. Oh, thank you. If you can move to the other end with your client, we're on the record. All right, we're back on the record. Are you Kevin DeLuz? All right, we're here because there's a violation report. It's the second violation report. Have both parties had a chance to review it?
Yes, Your Honor.
All right, they say that he's in the inclusion zone and that he keeps making unauthorized stops while he's on GPS. What are you all requesting, state?
Your Honor, I mean, at this time, the state would be asking for a bond to increase based on the violations.
All right, so why is your client violating his GPS?
Well, Your Honor, I guess first off, for an actual bond increase, I think the state would need to put on actual evidence.
No, they do.
Yeah.
So.
But Your Honor, my client is having issues in getting in contact with his probation officer. He's leaving messages to let him know he's going in for jobs, but he's not. Unfortunately, my client is in a desperate need to get there, and then he's not given. I don't think the problem is he's not given a sufficient 24-hour window. He's giving less than 24 hours notice to his officer, and so I think that's what his continued violations. Now, I understand a lot of
Some of these violations, they are not a place of residence.
no.
I mean, they're not a business, they're places of residence. For
Yes.
example, he's in Converse at Northampton Park. He's in Converse at a previous residence.
So, Your Honor, my understanding is my client was actually moving from this the 8134 Kentura Mills, and you're currently living at 8545 Copper Sky. Okay, he's currently living at 8545 Copper Scott. Copper Sky. Sorry, Your Honor. And so I think those addresses were the liquor stores are actually if you turn to the page to the GPS coordinates, it's within 300 feet. If you look at the next in that same shopping mall, the next business over is actually a barber shop. My client is a licensed barber. He is trying to get additional employment. Prior to this case, he actually owned his own business where he would go out and work on IT. He still does do that. However, given the nature of this case and the inability to leave his home and coordinating with that, he's trying to find a more stable employment 9-to-5 type of job.
No, but does anybody want to have the pretrial services officer zoom in? Because there are other things that are being said in this report.
And Your Honor, I mean, we're not going to contest that he's not going to AutoZone, Jiffy Lube, or these locations.
No, but it says the above mentioned defendant has been previously admonished multiple times for making unauthorized stops. When questioned the defendant, he confirmed that the following listed unauthorized stops were not work-related. So they're saying he's confirming that they're not work-related.
So, well, my client is stating to me, and I'm we can put him under oath here, but he's stating that the location that he just is describing that he was an unauthorized work-related stop with Walmart, which was for essential needs. And I will, in some of these, Your Honor, the Dollar Tree, the Chef Joe AutoZone, Jiffy Lube, those were to get car parts, Family Dollar, those are to get groceries. So it's my client. I understand he's not necessarily following the 24-hour window that his officer wants. Unfortunately, some of these needs are, he doesn't realize he needs them. I've explained to him that he needs to let him know, far in advance and keep written documentation of
Well,
such.
I will tell you, somebody changed his conditions. It was not the court, because I see here his previous condition was no contact with the complainant and full house arrest. Then someone came back and changed it to no harmful or injurious contact with the complainant and partial GPS. Here's
Yes.
the court's problem. He's not following GPS rules. If you don't want to follow GPS rules, then you're not on GPS. And I tell people all of the time, if there's an issue, you can come to the court. If you had an issue with your pretrial services officer being unable to accept your call, or you being unable to contact your pretrial services, all you had to do was make an unauthorized stop to the courthouse, the 187 District Court, which is located on the 4th floor. That's all you had to do.
Yeah, Your Honor, and that's partially a scheduling error with myself. My client has reached out to me to ask for a modification to GPS tracking only to assist him to stop having these issues. That is going to be a request that I believe is on file, but I understand it's not set for today. Your Honor, I was the attorney that did modify it. That modification was based upon receiving an affidavit from the complainant stating that she was not in fear of my client. She actually recanted one of the allegations as
All right,
well.
this is what's going to happen. State, do you have witnesses?
We don't, Your Honor, at this time, however, if the court would like to hear from the pretrial officer of the state, then we can try and take a hold of them.
All right, we can call in the pretrial services officer. I say we, the state.
Okay.
Are you going to object to them appearing by Zoom?
No, Judge, no.
All right, Ms. Ferguson. If you can have the pretrial services officer zoom in on this case. All right, just have a seat and we will continue.
Thank you.
You're welcome. Who's here on Alexander Rodriguez? Good morning. Your voice carries. He was able to hear you.
Sometimes, and then I have people sometimes who say they still can't hear me.
All righty. So on this case, you're scheduled for jury trial.
We're ready, Judge.
We're currently in a jury trial, can't do 2 trials at once. So Ms. Ferguson, recall this for jury trial, April 21st. All right. And they will bring you over dressed for trial in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. If there's an issue with it, let the court know.
We've already taken care of it, Judge.
All right, thank you. Oh, defense. I have some motions here
Yes,
for you.
Judge, it's one motion. They just stapled the motion in the order separate. I'm sorry.
And what was the previous amount that was given?
Oh, no, Judge, I'm
All
sorry.
right. If you can find
Let
out
me go.
what it is.
Do you have the file?
Oh, can I tell you, somebody took my pen. I think it's the pen.
I will give you another one, but you have to promise me I get yours.
Oh, yes, most definitely. Yes. Someone took it.
Let me get her.
All right, thank you.
So Judge Boyd is absolutely correct. She is in the middle of a trial. If you haven't been tuning into her channel, if you're looking for some afternoon court, I encourage you to do so. She's conducting the trial during her afternoon docket. It is in week 2 now. I've caught it where I can. I believe they're still calling prosecution witnesses as of yesterday. They haven't even moved into the defense yet. But again, it is a murder trial. It is complicated. There's a lot going on. So, yeah, give that a look if you're looking for something in the afternoons. Looks like Judge Fleischer is about to fall asleep. Again, I will most likely circle back on what Judge McNally is doing in a separate video. Other courts are in recess. So let's just continue with Judge Boyd for a little bit.
You know, are you ready with the interpreter? Yes. Okay. And who's here on Juan Manuel Clara Rascon?
I am, Judge. Good morning.
All right, and your client, Spanish speaker too. as
Yes,
well.
Your Honor.
All right, we have the interpreter here. If you want to speak to the interpreter, to have him brought up.
I've spoken to her already, Judge.
All right, let's bring her up and your client. Didn't I just attend your retirement? Ah, it happens. Let me see here. Right. Let me pull this up on Odyssey. All right, so we're here for jury trial.
Yes, Your Honor.
Court's currently in a jury trial. Ms. Ferguson? On this case, if you recall this for jury trial on the 21st? Unless your client wants a bench trial.
April 21st, Your Honor?
Yes.
Okay.
He doesn't address unless your client wants a bench trial. He's April 21st.
Yes, Your Honor.
All right. All right, sir, do you have any questions? No. All right, so you'll be brought over dressed in whatever civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. Counsel, if there's an issue with the clothing exchange, let the court know and I'll see if I can help expedite.
Yes, Your Honor.
All right. You have any questions, sir? No. All right, thank you. All right, who's here on Alan Mineros Pettis?
Morning, Your Honor.
Good morning. Good morning. All right, court is currently in jury trial, so we can't have his jury trial today unless you would wish to have a bench trial.
We would not, Your Honor.
Okay.
We'll go ahead and stick to our jury.
Thank
trial.
you for being direct.
Yes. ma'am.
All right, so we're currently in a jury trial, so we can't do two trials at the same time. You understand? All right, we're calling you back for April 21st for jury trial. All right, thank you. You'll be brought over dressed in whatever clothing, civilian clothing you have at the jail. If you wish to be attired in something different, you'll need to do a clothing exchange with your attorney. If there's an issue with the clothing exchange, let the court know.
I expect that to be done today.
All right,
So
thank you.
We should be good to go.
Is there anything else?
Thank you so much.
Oh, you look at that. Donata.
Thank
All right, thank you.
Thank you.
Thank you. Hey, let me ask you something.
Yes,
Are you gonna need, do you need an interpreter?
I think we had talked about that the last time I said no.
All right, so here's the thing. If you want an interpreter, then we'll give you an interpreter.
Okay.
If you don't need an interpreter, then we won't give you one. Do you need an interpreter?
No.
All right, let's go on the record.
Thank
Court
you.
is calling 2021 CR 6862, State versus Alan J. Mineros Perez for the defense.
Dante Dominguez for the defense.
And are you Mr. Alan J. Mineros Perez? Right, if you could speak in Spanish. All right, and could you raise your right hand for me to the interpreter? Do you solemnly swear and affirm you will faithfully translate from English into Spanish and Spanish into English, so help you God?
I do, Your Honor.
All right, you can lower your hand. Can you raise your right hand for me? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, speak in Spanish for now, okay?
Sí.
Yes. All right, the questions I am going to ask you are not about the facts of the case, and state you may be excused. The only questions I'm going to ask you is in regards to the interpreter. Do you understand?
Sí.
All right. Yes. Now, the reason why the court said we will have an interpreter here, because I think at first you were saying some words you don't understand. So we have an interpreter here. For your jury trial, we can have an interpreter as well who will translate from English into Spanish and Spanish into English. Do you understand?
I do. I see.
Spanish.
Sí.
All right. I do. Okay. Do you wish to have an interpreter at your trial?
No. No.
Do you wish to have an interpreter for any of these proceedings?
No.
No. All right. Do you need an interpreter?
No.
No. All right. I know ma'am is not the Spanish word for ma'am. What's the Spanish word for ma'am?
Señorita.
All right. Oh, look at me. I'm a señorita. I like that. You know, they always say, well, in French, you have different sayings or different words if someone is older or younger. So I'm a señorita.
Same in Spanish, Your Honor.
All right.
That was, yes, ma'am.
All right, then we can go off the record. Now that song is going to be in my head. The señorita song. All right, so we'll see you back on April 21st.
Okay.
And I'll notate that you do not need or want an interpreter. All right, thank you. Well, you too.
Thank you, Judge.
Let's head back to Judge Fleischer's court where he finally has something to do.
Can you run his license, please? He gets a license.
He doesn't know. So.
At 117 miles an hour, Mr. Shelby, I am now taking away your privilege to drive. I'm appointing you, Mr. Pruitt, here in the interest of justice now because your lawyer's gone to a funeral, but I'm putting these bond conditions on you now. And I want you to know that I will do everything in my power to protect my community at all costs. Do you understand?
Yes.
You are not allowed to drive.
Yes.
At all. You will be signing an affidavit. This is a promise that you're going to make to me that you're not going to drive. And if I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. Do you understand?
Yes, sir.
I'm also ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to put a monitor on your ankle so I know that you're not consuming. You will be tested for drugs and alcohol. If I find that you're using, likewise, I will revoke your bond and put you in jail. If you have a problem with drugs or alcohol, now is the time to address it. Because if you don't, and I see that it becomes a problem while you're on bond, I will address it for you. And I promise you're not going to like the way that I do it. Do you understand?
Yes, sir.
I am now sending notice to DPS that you're not allowed to drive any vehicle that's not equipped with an ignition interlock on it. Every officer in this state will know that if you're pulled over and you don't have an interlock on whatever car you're driving, they will arrest you and put you in jail. And that is a violation of your bond condition here. Do you understand?
Yes.
You're not allowed to drive any vehicle that doesn't have an ignition interlock on it. As it stands now, I'm taking away your privilege to drive, so you're not allowed to drive. You will get a device on your ankle so that we know that you're not consuming.
Yes, sir.
So he's not required to get the interlock unless you rescind that order for him not to drive?
Correct. You will get a STRAM device within 3 days. Within 3 days of your release, you will be required to get a STRAM device. And if you fail to do it, then your bond is going to be revoked. As it stands now, you haven't made bond on the DWI in your felony case. That's why you're still being held now.
That's a STRAM device.
It's a device that goes on your ankle so that we detect through perspiration whether you are consuming.
Drugs.
All right. I just wanted to bring you out to give you notice of the condition that we're placing forth on you now. All right? Okay. All right. So we need him to sign this and then sign with each and then.
Thank you.
All right. Thank you so much, Carl. I appreciate it.
Whatsoever or with court approved and properly said. How to install it.
Barbara, you're asking how Judge Fleischer is as a father. Obviously, I can't speak to that directly, but he has had his kids in court a couple of times. He seems to like to give them candy. Surprise. I know that he plays Xbox with them a lot. But that's really all I know. It is a weird morning out in the courtrooms at the moment. There's some things that it doesn't make any sense for me to pull up, like Judge Johnson in Southfield is starting a trial. But I don't want to get into that right now. Judge Fleischer's had a real quiet courtroom. Many are still in recess. Judge McNally just kind of pieced out after that sentencing. I think he wanted to avoid the crowd because I know there was some people that were highly emotional during that. Again, we'll try to do a video on that later. Let's go back to Judge Boyd.
We on discovery, and has an offer been tendered?
Yes, Judge. With regard to discovery, it seems to be intact. I recently today got access to 4 large files that I had to bring the external drive on, so I did get those. So I'm needing some time to review that, as well as the additional discoveries. Voluminous, there's at least 10 to 15 videos I need to review. So requesting a reset to review that new discovery, as well as the existing, Judge. Also, in reference to this case, I did file a motion to modify conditions of bond seeking removal of the GPS device. He currently still has it on, Your Honor. He's had it on since his release on pretrial services since July 29th, 2020.
All right, so let's take up one thing at a time.
Yes, Judge.
Ms. Ferguson on Mendoza, give me the discovery date for that is going to be May 20th, since you're already going to be here, counsel.
Perfect. Yes, Your Honor. Thank you, ma'am.
And let me see. Now, could I have the motion pulled on Mendoza? It's a motion to modify bond conditions. And State, are you ready to proceed on the motion to modify conditions of bond? All right, court is calling 2025 CR 001538, State versus Adolph Mendoza. Can I have parties announced for the record? State? Defense?
Renee Munoz.
And are you Mr. Mendoza?
Yes.
All right, defense has filed a motion to modify conditions of bond. The defense is requesting removal of GPS.
That's correct, Your Honor.
And State, are you prepared to proceed on the motion?
Yes. With regard to the motion, Judge, I don't believe there's any witnesses that necessarily need to be called. The circumstances regarding it are that July 29th, he was released on pretrial supervision, and that's of 2024. He's been on full house arrest, GPS, from that day, and he's still currently on that condition of full house arrest.
And I'm sorry, what date used to say?
July 29th, 2024.
Okay.
And there have been no violations rendered. He's been compliant with pretrial services, as well as seeing Center for Healthcare Services as a condition of that special needs unit bond. He's currently on medication. He's doing everything that the court is requiring him to do in terms of bond conditions. In fact, my client told me that he went to the pretrial office, and the pretrial officer recommended, since he's doing so well, for him to bring it to my attention. We can ask the court for some relief in terms of the GPS monitor. So that prompted me to make the request to remove the GPS monitor based upon 8 months, 10 days, no violations or incidents of any sort under full house arrest GPS.
All right, so what I can tell you, sir, is I don't like for GPSs to be removed and then 100% freedom, because then people fall off track. State, do you have any objection to tracking only?
State would prefer partial GPS. So
All right, and so why are you requesting partial GPS?
Because the defendant, Mr. Mendoza, and the complainant neighbors. I think it's important to keep track of where Mr. Mendoza is. Rather than allowing a greater degree of freedom. Additionally, Mr. Mendoza has a computer application prior acts.
Okay.
Your Honor, my client notified me that he's currently not working. His doctor doesn't allow him to work. So essentially, without it being changed to tracking, it would essentially render him still full house arrest GPS.
All right, so would you like, state, just a moment. State, would you object to partial GPS for medical appointments with a curfew?
That sounds acceptable. So no, would not object.
All right, so if you all can figure out a curfew time, so he'll be on partial GPS with curfew. All right, so if y'all will step back.
So with that, Your Honor, the curfew time, he would essentially be allowed to be out in the community, but aside from certain hours? Or
Yes.
Okay.
So the partial GPS, when I say partial GPS for medical, and I'm gonna have, this is gonna have to really be written very well for pretrial services. This is what I mean. Whatever time your doctor's appointment is, he's allowed to go. Whatever medical, he's allowed to go, even if it's outside the curfew. But if there is not a medical issue, then he is going to be on a curfew.
Okay.
So for example, if on Monday he doesn't have a doctor's appointment or any medical, then he has his curfew, whatever time that is you all agree to. If on Tuesday, let's say you all agree that his curfew is 5, well, doctors are usually, let's say you agree his curfew is 3 p.m., but his doctor's appointment is at 4 p.m. Well, he'll be allowed to go to that doctor's appointment outside of his curfew, but then immediately return back home.
So the curfew situation is like, say he wanted to go to the grocery store, as long as it was in that curfew, he'd be allowed to go to do something
Yes.
like that. Okay.
Yes.
That sounds good. Yes, Your Honor, we'll confer regarding the times.
I wanted to say something.
Mhm.
I want to get up because I usually take my kids to school and to work. That's why I really want to go, so I can take them to work.
Well, if you are on a curfew, then if the drop off and pickup is within the curfew window, then you'll be allowed to do that.
I want to make sure, because that's the reason why I want to get, that's my kids.
All right,
Yeah,
yes.
we'll work on it.
So defense, state, that's the agreement that you all have, that he's to have partial GPS for medical appointments with curfew. So I'm gonna hand the defense the order, and once you all
Yes, sir.
put it in there, that's what the court will order. You'll need to be back here on May 20th for discovery. Counsel, if you will get the reset form, you're excused once the reset form is signed. And once you all do that, I will sign it and you can make a copy and we'll make sure pretrial services has it.
Just to clarify, Judge, if when we come to this agreement and it's written on the order for your signature, do we have to reapproach on this one? Okay,
No.
it's on the side. Okay, great.
Yes.
Thank you.
You're welcome.
Okie dokie, since it's a little bit of a slower morning in court, you can all indulge me for a moment. First off, thank you to everybody who has said a happy birthday to Ellie. Ellie is my best bud these days. She is the kitten currently sleeping at my feet. She is 1 year old today. And April 8th is kind of an interesting date for us here at the Courtroom Files bunker. April 8th was first off and still is most important to me and Mrs. the Courtroom Files because this day, today, marks 18 years that we've been together. So it's important to us. Unfortunately, a year ago on April 8th is when we lost our first kitten, Jelly Bean. I say our first kitten here. It's the first one we'd had in over a decade. We did not bring our cats to Arizona when we came here for family reasons. We rehomed them with other family members. But we got Jelly Bean. We adopted her from the Humane Society. And I think I told this story on the live before, but she had been beaten to within an inch of her life by somebody. And We adopted her. We nursed her back to health. She had a broken leg, had trauma, vision problems, you name it. But we only had her for about 100 days, and you could see her getting stronger and stronger. And looking back on it, she was doing things to like challenge herself to see how well she was healing. But April 8th last year was when we had the solar eclipse, and all the animals were acting a little weird, and she snuck out the front door, and we have never seen her since. We still look for her. The light on the front of the house is still on and will always be on. But she just vanished. We think she was probably always an outdoor cat, and she just felt that call of the wild and returned to it. And maybe our job was simply to help her get back the strength that she needed to go live that life. But, you know, God's providence being what it is, Ellie was born the same day that Jellybean disappeared. But Ellie wasn't the first cat we got. We got Io, which I'll show you a picture of her at some point. I don't have one available at the moment. She's more Mrs. the Courtroom Files cat. Io is wonderful, beautiful kitten. She is a tortie, so she has kind of blacks and tans and stuff in her. Beautiful cat. But Io, who is only a couple of months older than Ellie, very much wanted to do kitten things, but she kept trying to do them with our pet rabbits, and that just doesn't really work. So we adopted Ellie to be a friend to Io, and Ellie is very much turned into my kitten. She's my best bud. So just thought I'd share. Let's go back to Judge Boyd. Yeah, she's really the only one with anything going on at the moment.
Yes, ma'am.
You're going to be on full GPS. So you're not allowed to leave your home.
Your Honor, with regards to employment, if the court were to modify it to full GPS house arrest, my client would unfortunately lose his job, and then at that point lose his ability to afford the house he's currently in.
Well, what he needs to do is he needs to provide adequate proof that he is employed and where this employment is located, and then the court will reconsider.
Okay, Your Honor.
So he'll need to provide that. And what I can tell you, if you provide that, I'm not trying to make someone be unemployed or not have funds, but if you provide that, then the court will strongly consider allowing you to work on GPS. And let me explain to you what the court's problem is. The court problem is that the report is stating that you are not abiding by their rules, and that they've told you before, these are the rules. You have to abide by the rules. I always tell everyone who comes in this court, if there's an issue, then we can come in and we can address that before we get to this point. And this is your second violation report with the court. Normally, we can go off the record. Normally, you know what other courts usually do? They just go ahead and rule on this. There would already been a warrant for your arrest based upon the nature of the offense. And the problem is with the nature of your offense, they have to know where you are located. I'm not the one who puts you on GPS. A magistrate judge or some other judge puts you on GPS, not me. But the rules that judge put in place for your GPS are the rules that I follow. Now, if it comes to a point in time where someone wants their GPS removed, or if they want a curfew or tracking or something else, that's something else we can discuss. What I can tell you in this court, asking for forgiveness instead of permission is not a good way to go. So all you had to do was come in and say, this is what's going on in my life. Can we modify GPS? And sometimes the state will agree on the modification. Sometimes they will not. But what I can tell you is if the state and the defense can't come to an agreement, I'll listen and I'll make a decision. Maybe I'll agree with the state's assessment, maybe not. Maybe I'll agree with the defense's assessment, maybe not. And then sometimes when states and defense, when you all have agreements and I don't think it's appropriate, then I don't agree with it. I don't do it. So let me just tell you what I need from you so that we can be clear. You will need to provide proof of your place of employment, and you will need to provide the hours that you work. And only then will I consider partial GPS for employment. And at that time, what I can tell you, it will be for employment only. You understand? Because I have to act when there is, based upon the nature of your offense, and there are these violation of GPS inclusion zones. And really, it's for your best too, because the complainant could say, you know what? This is where I was and I saw him. Or this is where I was and I saw him. You don't want that to happen. You understand? Yes.
There's no complaint. There is no complaint.
Your Honor.
No.
Stop.
Thank you.
Can I speak about something else?
No, it's just.
Let me explain something to you. You're saying that there is no complainant. I don't know anything about the facts of your case. You know why? Because nobody has presented facts of this case to me. All I know is what you're charged with. And what you're charged with is continuous violence against the family, right? So when there are charges, continuous violence of the family, robbery, murder, whatever it may be, the state, in some cases, you're saying that there is no complainant. There may not be a complainant that's going to come to court, but a complainant exists. Although we have had a case indicted before, none of these prosecutors indicted it without a complainant. But normally, there's supposed to be a complainant. And in your case, looking at the indictment, there's a complainant listed. So there is a complainant. Whether or not that complainant is coming to court or not, that's something for the state and the defense to worry about. I'm just here on this violation report. And what I'm telling you, other judges, and in the past, defense attorneys will tell you on these violations report before I took the bench, you know what previous judges would do? Just do a bond forfeiture or do an increased bond or remain without bond, and you will be brought over in orange. So what I'm telling you is you're going on full GPS. Your officer knows that it's going to be full GPS. Counsel, if he has employment, he needs to provide the hours and proof of employment to pretrial services. And then I will consider whether or not I will allow him to work while on GPS.
Yes, Your Honor. Well, if I may, he has provided that proof to the pretrial service officer who's not here today. I will have him email me that information again and provide that to the court coordinator as well as directly to Mr. Martinez.
And you all should ask Mr. Martinez if he has that. If you want to find out from Mr. Martinez if he has proof that he's employed and what his hours are, then
yes,
I'm assuming there will be no objection to hearsay.
no objection at that point.
State, would you have any objections to Mr. Martinez?
No, ma'am. I'm pretty sure Officer Bohack has got full credentials and everything. I'd be more than happy to provide him with his attorney. Just need a contact information. I'll send it to him right away.
All right. Thank you. What's your email address?
It's
well, let me have you write it down for me. And Officer Martinez, thank you so much. I'm going to put in the chat the defense counsel's email address.
Thank you, ma'am.
Rick, I'm sorry, what's your last name? Pena. All right, and if you go to include the state's attorney, Rick Pena, is it Richard really? Ricardo.
And Ashley.
All right. So if you can include Ricardo Pena in the email as well, he's the state's attorney. Okay, it's Zacery?
Yes, ma'am.
Okay.
Yes.
All right. All right, they'll send the email.
Thank you.
Thank you. And then we're also here because he said today, where are we on discovery?
I didn't realize we were already set. Your Honor, I believe we received the discovery on one of the altercations, the other altercation I need to get with the state. I didn't realize it was actually set for today.
I figure since you're already here, so
Yes.
that way he won't have to come back.
I will get with the state and confer with them about some additional discovery I do need.
All right.
We'd ask, I guess at this point, for a 30-day reset on the actual case.
Okay, just 1 second. Let me go to the summary. All right, it's actually set on May 5th.
That's perfect.
That's a good.
Yeah, that's
date.
a good date. We'll
Okay.
continue to confer about the discovery.
All right, so we'll recall you from Norma, if you can give a reset form for May 5th. All right, thank
Thank you,
you.
Honor.
You're welcome. Thank you, Officer Martinez, your excuse.
Okay, well, she's between things and there's not much else going on. The Casman, you just asked who put no in the poll. Well, thank you for asking that. Couple people have, actually. So I'm going to get philosophical for just 1 second. Why does that happen? I mean, it's such a positive thing to say 1 like equals happy birthday, Ellie, and 2 people don't want to say happy birthday, Ellie. People want to feel like they're accomplishing something, right? I think we all do. I mean, that's part of the human experience. You want to feel like you have something going on about you, you know what I mean? But unfortunately, so many of us don't have a clue what to do, or frankly, so many of us are so lazy that we don't put in the work of what needs to be done. Come here, sweetheart. I know. I don't want you knocking out my stream. So what I've noticed a lot, especially in the last few years, is a lot of people turn to destruction because it's easier to destroy than it is to create. You know, to do this YouTube channel as an example, I'm not trying to put me out on some kind of pedestal, just giving you an example. There's a lot that goes into it. It's a lot of hard work. It's hard to build this thing. It's hard to build a community, but that's true for anything of value. It takes a lot of effort. But unfortunately, a lot of people have figured out that destruction is incredibly easy to do. So they'll go negative. They'll try to tear you down. They'll try to rip you apart. And if they win, oh, good. A third person was nice enough to put in a no. Good. You're my example. People have figured out that it's easier to destroy. And then if they succeed and the thing they're trying to destroy disappears, they feel like they've accomplished something. But I'll be honest, I feel sorry for you if that's you, because that's no way to live a life. Because if you build something that's special, something that's meaningful, you have that to enjoy forever. If you destroy something in that fleeting moment, you can go, yeah, isn't that cool? And then it disappears forever, and you can never reflect on that as anything good, as anything positive. Just my philosophy on things. If you're that person, I honestly feel sorry for you, and I hope that you find a better way to live than to just go through life tearing things apart. But that having been said, it's all it all slides right off of me. I don't particularly care from a personal standpoint, because we have a great community here with a lot of supporters. You can see it in the comments. I appreciate it. Ellie appreciates it. And we love coming here every day to interact with all of you. But if you're the person who's just negative, I hope you find a better way. I really do. Let's go to Judge Fleischer. Looks like he actually has somebody in front of him.
The defendant is going to bond forfeit. When he comes back into custody, I will keep the appellate letter open, offer open for 1 second.
Yeah, we just don't know what circumstances are going.
Yeah, I understand.
So, I'll do 1501. Or, sorry, 2501. Hey, so 2501 on Wallace. And I'm not gonna do a BO. Hey, what's up? I like your MSU stuff. It's good stuff.
Thank you.
Greg.
Back on Delia, I don't see him in here. Thought I did. Let me double check.
That works.
Google.
No, that.
Do you have a?
No, he didn't have any his number.
Like physical address? Yeah.
Street.
911
They did a great job in this.
Lakes.
So, Greg, 5,002. I'm just gonna revoke.
Yeah, I
it.
figured. So he shows up again?
Yeah.
Okay.
Eventually get him. Yeah. And at that point, we'll do exactly what we were doing before. We'll do it now.
Hopefully he doesn't pick up a new case in the meantime.
Yeah.
Yeah, all right, thank you, Judge.
Thanks.
Judge, I did find out too, they will pick up on Saturdays. I wanted to say that yesterday.
Should have done it. Greg, stay on? Will you stay on? Since you know about everything?
Yeah, I mean, that's fine. It's, my concern is say I'm not here for the day. He pops up, but
If he pops up, you can always Zoom. I'll call you. We can always
Fine.
do it through
Yeah.
phone.
I also get someone to fill in if I'm not here on that day. So, all right. Sorry, excuse me.
Okay, alright. No, it's okay. It's fine.
Well, he's between things, Linkman. I want to be clear on something. I'm not implying that anybody is a bad person just because they click no on a poll. I'm saying that that type of thing is just one example of things that I see every day, not only on this channel, but out in the world in general, where people will tend to lean towards the negative, more towards the destructive. And I personally just don't think that's a healthy way to live. And as a society, I think we need to figure out how to do better about that. Those are just my feelings on the matter. I know this is a court channel. I try to focus on court, but we're also building a community here. So we talk about other things from time to time. And I think it's important that you have a little bit of an understanding of who the host is here and who you're interacting with every day. So you're going to have to learn a little bit about me and a little bit about what I think. And one of the things that really concerns me, quite honestly, and this is reflective of court, is the behavior of people. Why do we do the things that we do? And I've lived a lot of years now, and I will tell you that every year that passes, the more and more negative Western society seems to lean in its behavior. And it's bothersome. But I agree with you. It's just a poll. And again, I said it, at the end of the day, it doesn't matter to me. I mean, you can post whatever you want. And certainly Ellie doesn't know any better. She don't care. But I think it is a sign of deeper issues that we have. And one of the things, too, the older I get, I have a lot less days ahead of me than I have behind me at this point. I'm solidly in my 50s now. And I'm not worried about that per se, but it makes you recognize that days matter and how you spend your days matter. And it saddens me when so much of society is so focused on the negative, what that does to the quality of the time that they have, because it's not infinite. So this has less to do with me personally and less to do with a poll than it does me mourning for the way we all act and wanting it to be better. I hope that makes sense to you guys, hopefully, maybe. I don't know. Let's see what's going on with Judge Boyd.
In the box, Your Honor.
Oh, he's in the box.
He is.
Oh, Mr. Ivy, come down. Wow.
Nobody's seen you for a few years. She's asked, you.
Yes.
Okay.
We thought this day would never come. I feel like Dorothy.
It's been, the last time you saw him, Judge, was a week before COVID hit.
If only Glenda would have told me before to use the red shoes. I already had. Although as a child, I never was a fan of Glenda because one, I always said those were not her shoes to give.
I just saw something on that, where
And
she
then-
ended up being the one in power.
Oh, yes.
She knocked everybody off, the Oz, the
And
wizards.
she had other people to do her dirty work. So, and then involving a child to do her dirty work.
I just saw something about that a couple weeks ago.
So I've always rooted for the underdogs. All right, so on this case, he has been in federal custody. So your
Judge,
cases.
we are conferring, we did, obviously, this case just popped back up since he just came back to Bear County. As the state was reviewing, we did notice that we were missing, hospital records and CPS records, so our advocate is ordering that. Other than those, needing to be turned over to defense, that would just be picking up from the state's perspective.
And that's for the, sex.
3440 hospital.
All right. Anything else?
That's all.
All right, Ms. Ferguson, recall this for April 21st.
Thank you, Judge. And we're in touch, and I saw him 2 days after he was brought back, so everybody's,
Okay.
we know that this is old, and we're trying to see what we can do.
All right.
Okay, I don't know if we're gonna be able to do it though, Judge.
Okay. All right, so we'll have him brought back on April 21st. Thank you. And Norman, make sure that we put a hold on him.
Zark, hope I'm pronouncing that right. Why is she putting all the trials on the same day? That's a good question, and the reason is to make sure that something actually goes to trial if they call in a panel. What happens more often than not is these things at the last minute seem to get pled out, a deal is made. So if they go through all the hassle of calling in jurors and then selecting a panel and whatnot, and something doesn't go forward, no, you don't. They all have a waste of time and resources and money and everything else. So what all of these judges will do is they'll tend to schedule 3 or 4 trials to start on a specific day, and then there is a priority to them. For example, if the defendant is in custody, they'll go to the top of the list because they're in custody. It needs to be resolved faster. If it is a case where there's 2 that are out of custody, the older case would go first. So it's kind of a priority thing. And if there's 3 scheduled and 1 trial goes, the others will just be rescheduled. So hopefully that kind of answers that for you. Bodie, I agree with you, hating it when innocent people are pressured to take a plea deal. I hate it when anybody is pressured to take a plea deal, even if they aren't innocent. I mean, I get it from a resource standpoint and a do I want to take the risk of a trial standpoint. But you can argue that people will end up taking a plea, again, who aren't actually guilty, but they're looking for the faster way out. You could also argue that is justice done because of that plea? So did they get as good of a sentence as they probably, there's stiff of a sentence as they probably should have, which was something that got brought up in the video we posted yesterday. That cat today. You know it's your birthday and you got an attitude about it. But that was something that was brought up yesterday in the video that we posted about a plea that Judge Fleischer took. That really people have some strong opinions about in the comments there. But yeah, I wish more people would go to trial. More people are successful when they go to trial than what I've seen. In the last 6 months or so, there's been a change. A lot more defendants are getting found not guilty. Let's go back to Judge.
Can I have parties announced?
Andrew Verisadum for the state.
Sergio Ibarra for Mr. Morales.
All right, are you Mr. Morales?
Yes, yes.
All right, so the court received the first violation report. It's for high reading. Have y'all had a chance to confer on the violation?
We have, Your Honor.
And is there agreement?
I believe there's a, yes, we're in agreement with the recommendation of the state, Your Honor.
And what is that recommendation? And nothing else?
Right there.
I'm sorry. Nothing else, Your Honor. From that, I can, I'm happy to explain to the court, and
Yes.
he would be happy to explain to the court. He had family over. When I talked to him about this, he had mentioned that, you know, he had no intention to drive. I don't intend to have any drinks outside of the home, but I explained to him the requirement is no drinking whatsoever. I understand his intentions, but now that we've had a chance to talk about it, and I said in no uncertain terms to abstain from drinking alcohol, he's perfectly fine, and he's able to meet that requirement, Your Honor. I do not anticipate any further violations.
This is what the court is going to do. The court is going to continue with a mixed interlock. I'm going to add the alcohol awareness course. I'll ask that fees be waived, and there's to be 60 sober meetings in 60 days.
Understood.
And your next court date in this court, you're already set, I believe, for May 15th.
Yes, ma'am.
All right?
Yes, ma'am. Thank
You're
you.
not allowed to drink.
Yes, ma'am.
Do you understand?
Yes, ma'am. Understand.
All right.
Fully.
Thank you. Once, does he need a reset form?
I don't believe so, Your Honor, but just to be on the safe side, I probably will ask for one.
All right, Ms.
Yeah.
Ferguson, they're already set in the system for May 15th. If you could give him his reset form and double check that there's no issue with it.
Thank you, Judge, for your
You're
time.
welcome.
Appreciate
Thank
it.
you.
Thank you.
Okie dokie, let me address a few things in the chat, and then I'm probably going to call it a day because, again, it's kind of a slow morning all around in the courts. There's just not a lot going on. But to go back through here real quick, we're talking about trial. Linkman was asking, do pleas usually happen for serious crimes? Ellie, don't even think about it. Thank you. That cat today, she knows it's her day and she's got an attitude about it. Sorry. Do pleas usually happen for serious crimes? More often than not, yeah. I'm seeing more and more defendants that want to seem to go to trial, but a lot of the stuff is pled out. It's easier on the state from a resource standpoint. They're not spending as much money. If a defendant is guilty and they can get a deal that maybe looks a little better for them, they're probably going to take it. So it's quite common. There's more that seem to want to fight lately. And in some cases, if they're super guilty, I suppose, what have they got to lose? Especially if they're doing it on the public's dime with a public defender. But, you know, it does happen a lot. What else do we have in the chats here? I watched the one where the victim impact deal blew the thing up. Yeah, that's the video that we posted yesterday. More courts that I watch tend to do the victim impact statement after the proceedings are done and the defendant has been sentenced. But in this case, Judge Fleischer let the lady speak before he took the deal, and then after he spoke, he said, I'm not going to take the deal. Now, there's been some argument back and forth in the comments on that video that Texas law demands that that statement be done before the plea deal is accepted. Yes and no. It kind of depends on how you read it. It's not exactly as cut and dry as people would want it to be. But the court generally has a written version of the defendant's statement in front of them, and Judge Fleischer and the prosecution did, but he wanted her to be there and wanted her to read it. And it kind of changed the trajectory of that whole hearing. So if you haven't seen that video, go watch it. Again, there's a lot of strong feelings in the comments on that one, and I get it on both sides. But a lot going on there. What else do we have? People haven't been innocent arrested would say there was due process. All right, I think we're pretty much caught up there. I think I've addressed everything that needs to be addressed. Let me throw out a challenge to all of you, if I may, because we've done some philosophy kind of talk today, and thank you for indulging me. But one of the things that I've tried to do... Oh, real quick before I go there, somebody asked if I was a lawyer. Bodie, you asked. No, I'm not a lawyer. I don't play one on television, and I did not stay at a Holiday Inn Express last night. The whole reason this channel came around was because YouTube started pushing me courtroom videos, and I started watching them while I was doing my other work. But I've done other YouTube channels, and I looked at it, and I'm like, I think I could bring a different angle to this. So I started the channel, and it's blown up. So thank you all for helping me with that, and it would appear that my belief that I could do things a little bit differently, not necessarily better, just bring a different perspective, seems to be proving out. So I thank you for that. But back to my thought real quick, and then I'll let you all go. I would like to challenge all of you, not only in the interactions that you have on this channel or other channels, but in life in general. Look beyond the surface of what you see. And here's why I say that. If we go back to the video that I posted yesterday that we're just talking about, where we had Fleischer with the plea deal and how it all kind of blew up. So many people are on the surface level in the comments saying, this guy is guilty. He assaulted this woman, and you know, he deserves life in prison, all this kind of stuff. And then other people are like, that woman had no right to speak when she did and say what she said and all that and that stuff. And everybody is so reactionary rather than taking a pause for a minute and saying, okay, here's what's going on and here's what we know, and thinking it through. I would love to see more and more people slow down a little bit and think things through. And then whatever conclusion you reach, so be it. Again, I don't ever expect anybody to agree with everything that I say, nor would I want you to. That's a boring life. We have to have discussion. This is how we all learn and we grow. But we can't learn and we can't grow and we can't have good discussion if we're not actually slowing down and analyzing what's really going on. And that's true with anything in life. So my wish for all of you, we'll say wish, is to slow down and work through things that come across in your life. Think them through, think about what's really going on, and have a proper thought pattern and a proper reaction to it rather than just off the cuff going, this is what's going on. And I think we all improve and we all become better for it. Just my thought. Okie dokie. I'm going to shut up now and go ahead and leave it there. I do appreciate all of you tuning in. Ellie, wherever she ran off to, thanks you for wishing her a happy birthday. We will be back tomorrow. Oh, you got to be kidding me. Sweetheart. This cat is trouble today. The Kaz man, thank you for the $4.99. That's very much appreciated. Ellie, thanks you for that. We'll buy her some Cheetos later today. Or maybe some kind of netting to put over my shelf behind me so she stays off of it. But I'm going to shut up now. Thank you so much. I appreciate all of you. Take care. God bless. We'll be back tomorrow.